In Delaware, Wilmington, in a little repair shop named the Mac Shop, the owner of course named John Paul Mac Isaac, leaked documents, images, and emails from the computer of Joe Biden's son, Hunter Biden. However, this video doesn't follow the details of the leaked documents and the later fallout of those documents. But instead, this video looks at something much smaller, the reaction and or response from social media companies to the leaked documents. On October 14th, the New York Post published a story detailing the information contained within Hunter's laptop. However, on the very same day, Twitter and Facebook had taken measures of blocking users from posting links to the New York Post article, as the websites claimed the sharing of the leaked documents had violated their terms of service. Of course, with the actions from these companies, we saw the typical cries of censorship against the tech companies, with politicians once again decrying Section 230 and calling for it to be completely repealed. John Isaac himself was angry about the actions that social media companies had taken in regards to blocking people from spreading the story, specifically the actions from Twitter and the statements they had made when they had blocked users from sharing the story. The statement at issue is when Twitter had made the claim that the materials in the linked article had violated its rules against hacked materials. This eventually led to John creating a lawsuit against Twitter, alleging defamation since Twitter had called the reference materials to be hacked. Therefore, Twitter had called John Isaac a hacker. It seems clear on its face that this would be a win for John. The word hacker has some form of criminal connotations. Mac did not criminally hack into Hunter's computer. Twitter said the article contained hacked information. Therefore, Twitter committed the act of defamation. Did John Isaac win his lawsuit? No, he did not. Why? Because defamation is tricky like that. To get a hold of this case, let's start at the beginning. On December 28, 2020, John had first filed his lawsuit against Twitter in the Southern District of Florida. On the very same day, his lawsuit was dismissed. This was on the grounds because John had failed to show that there was enough diversity for the court to hear the issue, as both the plaintiff and the defendant were both based in the state of Delaware. A year later, on February 18th, John would file his suit again. However, with his residence being in Colorado this time, the suit would pass on the issue of diversity. Now, as I've stated before, the complaint for why Twitter is being sued is because Twitter themselves made statements claiming that the material is hacked, therefore calling John a hacker. For Twitter, though, they generally have 7 responses as to why the complaint should be dismissed. However, the judge will ultimately narrowly rule on this case on one issue, the issue of whether Twitter's explanation is defamatory per se. Twitter argues that their statement could never be considered to be defamatory, as they do not name either the defendant nor the defendant's business. In explanation, Twitter brings up the court case Horsley v. Felt. In the case of Horsley v. Felt, Neil Horsley had sued multiple people and organizations claiming that they had made statements exclaiming that he had aided or acted in conspiracies to murder doctors. For one of Neil's claims, he references an AP article's report on Felt's statement. However, in the article, Felt does not mention either Neil, nor at least names Neil's website. So Twitter argues, using the judge's own words, that defamatory words must refer to some ascertained or ascertainable person, and that person must be the plaintiff. Twitter argues that the defamation claim fails on its face, as their statement does not expressly identify him, or at least his business. Now, John argues that Twitter is incorrectly applying the law. He does this by showing that an individual does not need to be named for a statement to be considered defamatory. John brings up the case Wolfson v. Kirk, as it writes, "As a matter of law, a defamed person need not be named in defamatory words if the communication as a whole contains sufficient facts or references from which an injured person may be determined by the persons receiving the communication." John goes on to argue that by reading both the New York Post article and Twitter's tweets, a typical reader would know that Twitter was referring to the repair shop's owner as the person who initially hacked into the laptop's computer. The article clearly states the shop owner initially accessed the data and then gave it to Rudolph Giuliani's lawyer. This statement and the case law before it is a bit of what we call a Chekhov's gun, as it hints exactly what issue the judge had with John's lawsuit. As we note from the Wolfson case, the defamatory statement must at least reference the plaintiff in the communication as a whole. However, John relies on an outside source to be the point of reference. John has basically shot himself in the foot with Chekhov's gun. The judge does agree with John that the person does not need to be named for defamation to occur, but as said before, John relies on an outside source for his defamation claim. We see later in the judge's order, the judge brings up the case O'Neill v. Tribb, as it notes that defamation cases where a person isn't named in the suit, that the communication as a whole must contain sufficient facts or references from the injured person may be determined by persons receiving the communication. So the issue becomes is whether from just reading Twitter's statement alone, could they infer that Twitter was referring to the plaintiff? John himself argues that you couldn't tell if Twitter's statement was defamatory, but you had to rely on the New York Post article to figure out who Twitter was referring to. It fails because the additional information to make Twitter's statement defamatory exists outside of Twitter's statements as a whole. So that's why John Isaac's lawsuit failed. The basis of his lawsuit relied on information existing outside of statements not by Twitter to build his lawsuit. He built his lawsuit with faulty foundations, and then his lawsuit collapsed because of it.